If it pleases my lords and my lady, my name is Wanjiko Waithera for the 9th petitioner. I will take over from where my senior and colleague has left out. My lords and my lady, Article 259 of the Constitution is the bedrock of constitutional interpretation, and it requires that the Constitution shall be interpreted in a manner that promotes its purpose, values, principles, and advances the rule of law, and human rights and fundamental freedoms of the Bill of Rights. Further, it shall permit the development of the law and contribute to good governance. My lords and my lady, relying on the Court of Appeal decision of the Attorney General versus the Law Society of Kenya, 2019, the court emphasized that the principles of, that in interpreting the Constitution, we have to look at the holistic interpretation of the Constitution, such that the various chapters and articles of the Constitution are read as one document and not as disjointed sections where each provision is destroying the other. Further, the court noted that all provisions have to ultimately be in harmonious symphony. The Supreme Court, in the decision of the Kenya National Commission on Human Rights 2014 EKLR, defined the meaning of what holistic interpretation of the Constitution is. And the court noted that the Constitution has to be taken in context. It is the contextual analysis of the Constitution, reading it alongside and against other provisions so as to maintain a rational explication of the Constitution, meaning that the history of the articles has to be taken into consideration. My lord and my lady, we have raised two substantial issues in the impeachment process. And the first one is whether the nomination of the deputy president can be legally finalized or approved in absence of a fully constituted IEBC. Taking a reading of Articles 82 of the Constitution together with Article 88, which enumerate the functions of the IEBC to include regulation of the process by which parties nominate candidates for election and monitoring compliance relating to nominations of candidates. My lords and my lady, the two provisions, and by extension the IEBC, provides electoral oversight and approval of candidates for nomination. It is not in dispute that at the time when the second interested party, Honorable Professor Kindiki, was nominated for the position of the deputy president, there was no properly constituted IEBC, with various commissioners having either resigned or retired. The Supreme Court recently, in the decision of IEBC versus AG, an advisory opinion 2025, sought to draw a clear distinction on what the administrative roles of the Secretariat and constitution mandate of the IEBC ought to be. And the court noted that it is our considered view that the exercise of constitutional functions expressly reserved for the Commission, such as those enumerated under Article 88(4) of the Constitution, cannot be lawfully discharged in absence of a properly constituted Commission with the requisite quorum as contemplated under Article 251 and 252 of the Constitution. My lords and my ladies, it is our humble submission that the nomination of the second interested party ran afoul the provisions of Article 88 as read with the 82 of the Constitution. We submit that the principles that the court articulated, that the Commission must be properly constituted, cannot have been discharged in order for the IEBC to discharge its mandate, has to be held in equal, if not greater, force when it comes to approval of the second highest position in the executive of the Republic of this country. My lords and my ladies, the second issue that I seek to persuade you is whether the nomination of the second interested party, while serving as a cabinet secretary, violated provisions under Article 148 as read together with Article 137 of the Constitution. It is not in doubt that at the time of nomination and even approval of his role as to take over the role of the Deputy President, Honorable Professor Kindiki, serving the people of the Republic of Kenya as a Cabinet Secretary for Interior. Sir, under Article 260 of the Constitution, includes persons holding the position of Cabinet Secretary. He had neither resigned from this position at the time when Parliament approved his nomination. My Lord, and the only exception that the Constitution provides for persons who can be nominated for the presidential position are people who are already serving as a president, a deputy president, or a member of public. None of these positions, the second interested party was not serving any of these positions. And therefore, we humbly submit that a person who already holds a position of cabinet secretary at a time of nomination as a deputy president does not satisfy the constitutional qualification set out in Article 137 2B as applied through 148. And therefore, the nomination of the Honorable Professor Kindiki runs averse the said provisions. My lords and my ladies, via our petition, that is petition number 565 of 2024, we had sought the following reliefs. The first one is a declaration be and is hereby issued that the rights and fundamental freedoms of the first petitioner, including his rights and freedoms under Article 25C, 50, 27, 47, and 145, were grossly violated by the third respondent on the 17th day of October by declining to allow him an opportunity to adjourn and be heard during the sitting of his removal by way of impeachment. The second relief we have sought is that a declaration be and is hereby issued that the decision by the third respondent to have the first petitioner removed from office by way of impeachment, to the extent that it was done in gross violation of Article 25, 50, 27, 47, and 145, 5, is unconstitutional and null ab initio. A declaration that subsequent replacement of the first petitioner to the office of the deputy president was also unconstitutional. We've also sought a judicial review of order of certiorari to bring to this court for purposes of quashing the Gazette notice by the third respondent dated the 17th of October, communicating the removal from office of the deputy president of the deputy president by way of impeachment. A judicial review of certiorari does hereby issue to bring to this court for purpose of quashing the decision of nominating Professor Kindiki as the deputy president of the Republic of Kenya for failing to meet the qualification under Article 137 2B and 3 of the Constitution. In the alternative to that fifth prayer, we have sought that the Honorable Court does make a declaration that the appointment of the Deputy President to fill vacancy arising from the removal of the first petitioner from office pursuant to Article 149 of the Constitution must be read together with Articles 82 and 88 of the Constitution to give the IEBC its constitutional mandate of approving the name of the nominee as proposed under Article 149 of the Constitution. We have also sought a declaration be made that the approval of Professor Kindiki or any other person as the Deputy President of the Republic of Kenya is subject to Articles 82, 88, and 137 of the Constitution. We've equally sought cost of this petition. My lords and my ladies, I have refrained from regurgitating what fellow counsels for the petition has highlighted in respect to the impeachment processes and the violations that we witnessed therein, including public participation and the violation of the right to be heard by the first petitioner. All those are contained in our submissions. That is all, my lords and my ladies.
Thank you.